the point I think is, that's the registration statute, right?
Right.
But in the designation statute that we're debating here, they don't have those federal crimes
No, they-
listed.
they do
But they
not.
have the same language about registering in a foreign jurisdiction.
Yes.
So it seems a deliberate choice not to have those in the designation section when you had to put them in the registry.
So the amendments that were added in 2002, they were in response to challenges under the essential elements test of whether or not the federal offender should be required to register under New York State SORNA.
But I'm assuming that
But-
essential elements test is the same in the definition in 3B, because that has an essential elements test in it too, right?
Yes, it does.
So if they had to amend the first one on registration because the essential elements test arguably didn't cover it, it seems a concession that also Romanet 2 of 2D didn't cover it, which is a felony in any other jurisdiction for which the offender is required to register as a sex offender.
That foreign jurisdiction clause that designated Mr. Sherlock as sexually violent in this case offends under
I'm saying if they
Included-
felt they needed to add it to 2D, which is essentially the same language as 3B, to cover these federal crimes, to capture them, why don't they also need to add it to 3B, which has the exact same language? The exact same language that you're saying captures those federal crimes. They felt the need to add the federal crimes specifically in order to fall within that provision.
because there were challenges regarding the essential element, whether or not the federal crimes had the essential elements of New York crimes to render those.
But why do you need to get to essential elements? Your response to that litigation should have been, no, don't worry about it. We can just go to Romanet 2, which is it's a felony in another jurisdiction for which registration is required.